Всем доброе утро. Мы уже решили медленно, но верно начинать. У нас сегодня два модератора, что само по себе уже очень сложно, потому что они всегда перебивают друг друга, не могут ни о чем договориться, а в нашем случае даже еще и говорят на разных языках. Я позволю себе на нашей панели «Экстерриториальное действие национальных законов о риске транснациональных компаний», а прежде всего представить нашего модератора, Алан Томпсон, Director of RBCC. Alan became incumbent in April 2012. He is the head of both offices in Moscow and St. Petersburg, and also Alan is representing Great Britain in the National Council of the AEB. That's a very important association. In principle, he is a friend of Russia since long way back. He came over to Russia in 1999. I think he was looking for adventures, but he stayed on. He worked in different background businesses, agriculture projects, insurance projects, selling advertising venues, and supplies of hygienic and disinfectant means to the hotels of Russia. If you have this hotel in problem in hotel in Russia, you should turn to him. He is from Scottish background. Sometimes he is wearing a kilt, and he's very proactive participant of a whiskey club in Russia. And there is one very significant thing which unites Alan with many people present here, namely he is the master on commercial law of Leicester, which is very commendable as well. So Alan, thank you very much for being with us, for moderating.
Thank you very much, Oksana. Indeed, as a friend of Russia, it is a great pleasure to be here this morning, and also to have the pleasure of introducing Oksana Balayan, the managing partner of Hogan Lovells this morning, the host of our roundtable, someone who has an exceedingly long and very overqualified in the area of Russian and British and in fact indeed German law as a doctor. She graduated from Lomonosov State University in the first instance, is a doctor of Regensburg University in Germany, has worked and had exposure to Columbia University, Netherlands, European Legal Academy in Florence in Italy, and Harvard Business School. And so in fact, I have to be exceedingly careful with what I say, precisely because I'm sure that Oksana will be cross-examining all my words. Oksana is specialist in cross-border mergers and acquisitions, particularly with an accent on corporate finances, joint ventures, has again a very long list of clients with whom she has represented, including Alexander Manmut, Mr. Friedman in X5, Mr. Pompiansky in Sinara TMK, and as I said, a very long list of others. She has been recommended in the Legal 500 as one of the best lawyers in Russia, and as the title of Deal Maker of the Week in the American Lawyer, as I said, I believe Oksana is overqualified to very much assist me with my insufficient, perhaps, knowledge of the legislative side of today's discussion. And for that reason, it gives me great pleasure to introduce her and to be alongside her, hopefully not to interrupt her too much. As Oksana said, today's discussion is dedicated to the extraterritorial effects of national laws and transnational corporations and risks. Before going much further, I wanted to introduce the other speakers around this table. Again, we are very lucky to have a varied number of different people from different practice, different legislations, different jurisprudence experience, both in the terms of transnational organizations and practicing lawyers. If I can start over there on the right-hand side with Michael Swainston, barrister from Brick Court Chambers in London, again with a broad experience in commercial litigation, advisory practice in England, representing Russia in a number of current legal litigation, with an experience as in energy litigation, insurance, reinsurance, banking, and I think the interesting one here for today's discussion is also Islamic banking and the way that may influence us going forward. He is admitted in practices in BVI in Dubai, and extensive practice before international arbitration panels commenced under LCIA, ICC, and Bermuda form rules. Again, Michael, we're very grateful to have here today, given his experience. So thank you very much for coming. We have opposite Michael, Daniel Engelbrecht-Nudling, 15 years of experience as an entrepreneur and investor, so a very much pragmatic lawyer, someone who has a deep area of experience in advising clients in the area of mergers and acquisitions, in investments, and has experience, legal experience from universities of St. Gallen, New York University, Harvard, London Business School, etc., etc. Again, a very long list of education and qualifications. At the moment, he is the principal owner and supervisory board member of FNC Holding Fulda, which is the largest building material company in Germany, with 12 production sites. Obviously, the area of construction is a very positive area and a very interesting area with regards to where we are in Russia at the moment. Thank you very much, Daniel, for being with us. We look forward very much to your experience and the way you share it. Swiftly moving around the table, we have Mr. Mikonin, partner of SK Vertical Legal Firm. He is the head of litigation. Particularly, Mr. Mikonin is focused on litigation and mediation in arbitration disputes, setting up trials abroad. He represented the judicial department of the Russian Supreme Court in property disputes with commercial companies. He has represented clients in the Supreme Arbitration Court of the Russian Federation, which leading to the change or amendments in the Code of Inland Water and particularly riverboat mortgage procedures. He has filed claims against Russia, and foreign media, public agencies participated in a number of large-scale information wars, which again I think is a very relevant area for today's discussion. Andrei will be particularly leading us off in the area of the Eurasian Customs Union a little bit later on. To my left here immediately, I have the pleasure of introducing Yelena Chelembayeva, corporate lawyer for Volvo, who has been with Volvo for 2008. She is also a graduate from the Moscow State University and has extensive experience in advising Volvo through compliance and all business divisions of Volvo in Russia, including heavy transport Volvo and Renault, the construction equipment of Volvo, and again an extensive experience in the localization of Volvo with regards to their factory in Kaluga and the current practice around that. Yelena specializes in the area of private law, Russian private law. And finally, to my right, we are very honored and pleasured to be joined by Mr. Mark Friedman of Philip Morris International. He joined in 2000 as regional counsel in the EU. Mark became vice president in 2002 and is associated general counsel for Western European region in 2005. He became vice president, and now he is senior vice president and general counsel in 2007. Was deputy general counsel for in 2008. Sorry, Mark has worked in the area of litigation, obviously with such an organisation such as Philip Morris Transnational organisation, working in litigation issues for more than 10 years in New York, Hong Kong, with the offices of Cleary, Gottlieb, Steen and Hamilton. He is a member of the New York Bar and has earned a law degree from Harvard Law School, an undergraduate degree in public and international affairs from Princeton University. So thank you very much, our panelists this morning, for being here and for agreeing to take part in what could be a very interesting discussion, what I hope promises to be a very open discussion. We also very much rely upon our audience this morning for their input, for their questions, and there will be an opportunity to take part in the discussion a little bit later on. Before moving on to the meat of discussion today, I just wanted to point out administrative issues. We will be having the discussion both in English and in Russian, and for those who have not yet worked it out, I believe English translation will be on channel 5 and Russian translation will be on channel 6. I hope that everyone is ready for a very good discussion and look forward to taking part. As we said already, the extraterritorial effects of national laws. What we're interested in is talking about the supranational effect of measures and how they affect where the crossover point is with the national legislation. We will be looking to make some, I hope, some conclusions towards the end as to the dynamic, whether it's more towards supranational issues or whether there will be a reassertion of national legislation, and we will be structuring our discussion this morning into three main areas. We will be starting the discussion this morning with regards to sanctions and the current situation of sanctions, obviously with a certain optimistic hope that by the end of July something else may happen. I don't know, we'll see. We will be then moving on to mergers and acquisitions and the application of legislation issues in M&A area. And then, as I said earlier on, we will be moving the third part of our discussion this morning. Before going into questions, we will be looking at the Eurasian Customs Union, the significance of the development of this with regards to the issues of extraterritorial effects of national laws. From my side at the moment, I think that's perfectly enough, and I'd like to hand on to Oksana for more of a legal aspect and understanding of the issues that we're going to be discussing this morning. Please.
Thank you, Alan. Вы знаете, здесь очень сильное эхо и много параллельных сессий. Организаторы предложили всем надеть наушники и слушать нас прямо и по-русски, и по-английски.
And listen to us to the headsets. It will be a more focused sound, but that's left for discretion of you. It would be challenging for me just keep sitting on in those headsets, but that's the way it is. It's a strong echo here. Now, if we are to refer our subject matter to legal avenues, I would like to come up with some introductory part as to about what this extraterritorial action of national laws is all about. Why do we bring this up now? On the whole, many have been through it during the university when they study law. Unlike international treaties, national legal acts have got a legal force on the territory of the state where they were taken into effect. That's what we know, that's what we've grown up with, but recently the situation started turning around in this global world with those current trends. When globalization permeates all the level, the borders obliterate, and oftentimes we see the examples that the laws started transcending those borders. Extraterritorial nature is all about the fact that all the persons having the origin of one and the same country whereby this law was enacted, the law of extraterritorial force, they should comply with the norms of this law, of this legislation, not only on the territory of their own country, but in any point on the planet, wherever they are. That's the general principle of extraterritoriality. Now let's get down. What is the origin of the person, the origin of a country? For a household, it's nationality, or sometimes is the residence permit even, or sometimes it's some kind of a visa. We should keep that in mind. When you obtain a visa of another country, it might happen at the end of the day that the laws of that country will also cover you even if you're outside. For a legal entity, it's the place of their incorporation or the place of conducting business. And even here, there are some implications and undertones. Let's say the company was incorporated in Russia, but it has got a subsidiary in some country, that's in the US. On this principle, even, this Russian company with its subsidiary will be under potential action of extraterritorial laws of the US. You should verify that. You should keep good care of structuring your business. You may be surprised, but we verified the statistics when we were preparing for the session. Turns out that for the liability for violation of American extraterritorial legislation, more foreign companies are sued whose subsidiaries are outside the U.S. vis-a-vis American companies. You should keep that in mind. Those who studied in America, you know that American students, they make a joke. It's enough for you to go on the plane and fly over New York State state in the air, and you'll be in its jurisdiction, and sometime after, at any point on planet Earth, you could be sued. So just take care and look over which countries you fly in a jet. And other examples of extraterritorial laws are those acts with whom most of us encountered recently, acts geared towards countering corruption. We all know what FCPA is, and UK Bribery Act, ABAC. This is a new legislation altogether, but this has been changing, and it gets sterner and sterner. M&A deals before, previously those legal acts were not important for us. Now, during the due diligence, we see that there is the verification for FCPA and ABAC and others. So we'll speak about that later. From the standpoint of extraterritoriality, the essence of anti-corruption law is all about the fact that UK and US companies acting in the territory of Russia and other countries are to comply with that legislation. And by the same token, their subsidiaries should. Another example, more topical for us, this is about the norms of extraterritorial nature, sanctions of EU and American and other countries, notwithstanding the fact that in our country sanctions law goes into the reverse direction. The companies who work here and of the origins of the country of sanctions, they have to comply with the legislation of those countries. That's amazing. We read mass media, we dislike certain things, but that's the way it is, and that's a choice for a business. What's to be done? Either we keep on working in Russia but take into account those norms, or we quit because nobody understands why we should comply with those sanctions. That's a very hot topic. Maybe we'll continue it. And we should keep in mind that Russian laws, by the same token, are of extraterritorial nature, like our antitrust law. It requires getting compliances with all the transactions to be approved by antitrust authority, even if they were signed overseas. Another one, that's deoffshorization. That's the norm, which is extraterritorial norm as well, and we're fully aware that we cannot possibly avoid it. We should study it thoroughly. We should know how to work with CFCs and how to structure business in the right way in case of a CFC. One of the most unappealing examples, because we don't yet know the answers, is the law on personal data protection. That is also the example of extraterritoriality of the law. If Russian legislator, in order to protect the interests of many parties to this process, make a law about where and how personal data is to be kept, that could have very strong repercussions on the way this data is transferred overseas, to which country do those respective countries have got this law on personal data protection. Let's say if those data are processed in Russia, in US, and where the server should be. That evokes many problems. It's necessary to structure your activity in the right way, and for lawyers it's always about the necessity or ability to render services to prompt how to do it really. The number of those extraterritorial norms have been growing. They impact all the sectors of our business, all its aspects. Oftentimes in the past they were underestimated. We're saying no big deal, it's not our legislation. But currently we should not be so offhand with those norms. So now we'll get down in more details to several main blocks working on those norms. And the first topic we decided to discuss is sanctions.
Indeed, and we decided that where better to start on the topic of sanctions than the United Kingdom. Mr. Swainston.
Thank you, Alan. It did seem to me that the topic of extraterritorial application of national law and the risk to international corporations as a result is a very big subject. And so I wanted to focus on sanctions, and also to be a little different. I didn't want to focus so much on the risk to corporations which are the target of sanctions. I want to talk a little bit about the risk to corporations which apply sanctions that are lacking in legal foundation. Now, the first thing to notice yes, who knows who's interfering with it? You don't know what I'm going to say. The first thing to observe is that there is a very significant question over the legality of sanctions. And essentially, there are two ways of imposing them. One is through the United Nations. One is through the United Nations, which one might call the legal way. The other is by way of unilateral sanctions, which one might call the US way. In relation to unilateral sanctions, there are very serious questions of legality under public international law. The first is substantive illegality. The second is jurisdiction. And the third is collateral impact of sanctions. Now, so far as substantive legality is concerned, I've drawn attention to a General Assembly resolution which calls for elimination of sanctions, particularly against developing countries, and seems to frown upon unilateral imposition of them. There are also jurisdictional objections. As a matter of public international law, you are not entitled to apply your national law beyond your borders without a jurisdictional excuse. And there are various of those potentially in public international law: objective territoriality, the effects doctrine, the protective principle, the nationality principle, and so on. But none of these justify what I've called the US approach to sanctions, unilateral sanctions, particularly when they are applied to foreign corporations. And so if we turn to United States sanctions, which are generally in the vanguard, America tends to rely upon the nationality principle. However, it applies its sanctions to corporations established abroad which are owned by American interests. And my view is that that contravenes the public international law recognition of the independent personality of companies. So clearly the risk to companies which are the target of sanctions is huge, and we see from the headlines that the figures are astonishing. But it's also the case that there are potentially risks to states and corporations which actually apply these sanctions. And that's especially so in what I've called the deliberate penumbra of sanctions. Because if, especially in Europe, you're advising Russian clients or Iranian clients about the impact of sanctions, a particular problem is sanctions applied by European companies beyond the letter of the sanctions law. And if you look for official guidance on how the sanctions apply, it's very often lacking or deliberately vague, and it's difficult to resist the conclusion that the sanctions are drawn in an unspecific way to encourage or intimidate European corporations, banks especially, into applying sanctions in a penumbra beyond their proper scope. Now, that carries risks for the banks involved. Sometimes there's violation of local law. For example, on some occasions, for example in relation to some Iranian sanctions, there can be an EU blocking statute. These days, especially in relation to Russia, the EU disagrees with very little in terms of sanctions coming from America, so one can't really have much optimism for application of a blocking statute. There may, though, be scope for breach of contract, because if banking services are withdrawn without a legal excuse, then the bank can be sued. And there may also be scope for regulatory action by authorities responsible for banking, which may be properly concerned that banks are not offering a proper service. Now, of course, regulators are led by their governments and they lack enthusiasm for this kind of action, but I would suggest that they can be forced into it, and I'll come to that in a moment. Another interesting possibility is use of competition law against banks, which apply sanctions that do not have valid foundation in public international law. And this case, the deoffshorization transfer case in the High Court in London, is an example. In that case, the English High Court granted an injunction to stop Barclays Bank from withdrawing banking services to a company involved in money transfer, particularly with the Middle East, which Barclays did not want to deal with. And no doubt the background to that was anxiety about sanctions and maybe upsetting America, where no doubt Barclays has operations. The injunction came because there was a good argument that Barclays had a dominant position in the banking business, and so it should not withdraw banking services, and if it did so, that was an abuse of a dominant position. Now, if you take that principle and you combine it with the fact that many banks providing exchange services or clearing services, particularly to Russian clients, together can hold a dominant position, then I would suggest that there can be abuse of that dominant position if those banks together apply sanctions that either do not have legal foundation or apply restrictions which go beyond the letter of the sanctions. Now, I mentioned that there may be a way of encouraging states to take action against those who apply sanctions which go beyond public international law. The argument would be this: we live in a global and integrated world. Every person and every business is integrated into the world economically. And therefore, if you deprive people arbitrarily of access to banks, you are fundamentally violating their human rights. Their human rights in terms of their property, their human rights in terms of their family, their human rights in terms of livelihood. And it does seem to me that where states, and particularly banking regulators in Europe, tolerate what I've described as the penumbral effect of American sanctions in particular, then they should be subject to review before their own courts in the first instance, but ultimately in Strasbourg for violation of the European Convention on Human Rights. Now, of course, if any of those methods succeed, and retrospectively it's established that the sanctions were illegal or that they were being applied beyond their scope, then in my submission there would be very serious risks for the European banks that applied them in that way. That's an introductory comment, I hope not too long.
That's a very helpful background, I think, and the principles which you explained, I think, are not entirely on the surface when you start talking about sanctions. So it's interesting that we see this interaction. Yeah.
Indeed, I think that the issue and the solutions that you are making reference to are perhaps give a certain amount of hope to some of the transnational organizations present, perhaps with reference to something that could happen in the near future. But I would like to ask Yelena Chilimbayeva from Volvo to give her share her a little bit of experience on the issue that you mentioned, the necessity for certain transnational organizations to do due diligence on some of their partners in country when it happens to be in violation of the in-country antitrust laws. Please, Yelena.
Yeah, thank you very much. I see here several topics. First of all, of course, it's quite difficult to make due diligence of all customers, how they are connected with the designated parties or connected with the sanctions. I have very interesting experience. I worked in European country at the moment last year when sanctions was imposed, and for example, responsible public authorities in Europe, they sent to transnational companies questions. Do you know what does it mean Arctic shale, and how do you provide due diligence of your customers? They are not connected. So it's interesting that even public authorities in European Union, they was not very much prepared to be responsible for sanctions. And my experience that interesting part, different sanctions. Now we have sectorial sanctions, we have particular asset free for particular people. Different public authorities inside one country are responsible for financial sanctions and for example, different military sanctions, and they have different opinion, interpretation, and approach to this legislation and comment to international companies. Moreover, I met a very interesting, I did not expect this, I would say, forum shopping. When you're a European company and you need a particular advice, for example, for these sanctions, it was a question. Some companies who are under sectorial sanctions would post-payment conditions on the purchase agreement should be treated, qualified as these 30 days debts, because looks like it's more for financial instrument instead of purchasing agreement. And usually international companies, they have sent this question to different countries, because if you're a member of European Union, you can ask any public authority in European Union. And what is interesting, a really different speed in answering and really different position. And it's some kind of forum shopping that international companies could just choose more convenient or flexible position and follow its advice. It's also interesting inter-European Union, some kind of how it is collision or something like this. And what is very interesting, when I discuss the sanctions with different my colleagues, and we should do this and this, and told, sorry, but we have small issue like Russian antitrust law. We just cannot reject or deny to enter into agreement with the particular Russian companies because it is under sanctions. But we have antitrust legislation. Like classical example for many companies, it is how should we reject to have deals just because company is registered in Crimea. Very interesting comment about human rights, by the way. And it is internal researches, huge internal researches for European companies, not clear interpretation even inside European Union, plus not clear position of Russian antitrust authority, which is quite pity. And as we discussed, even antitrust authority could tell, we understand the political background and so on. If particular company would complain to Russian antitrust authority, they should react and they should follow Russian law. For me, it's like, some kind of international public law, like international private law. If we have some battle between jurisdiction, there is no rules what we should do. And in my experience, international companies, I talk not only about my company, my experience in communication, that companies just simply calculate where fine is lower. What to do? okay, we should breach either this or this law, where consequences is lower. And when I did, as Oksana today, remember university, and all professors told, you should never think as lawyer what is consequences. You should more think what is the sense of the law and so on. But in practice, at least in this field, everybody thinks about consequences. And this is really, I would say, for me, pity. This is strange legal environment. Thank you.
Elena, that's really very practical experience which you show. And in your professional and corporate experience, do you have to make these choices? And if you have to make the choices, is it indeed about monetary value of the risk?
Yeah, first of all, monetary value of the risk, consequences, I would say, because, in reality, of course, from global perspective, I think for most of international companies, Russian market is 3-5% of revenue. Of course, it's better just to stop to do any even border deals or any risky deal instead of making a risk for European Union. But at the same time, we know that from labor perspective about human rights, a lot of people can lose job in European Union. And we had in Russia a very interesting case. It's a labor case. One of the American pharma company, they made internal instruction how should be provided due diligence of the customers, and employee did not follow this instruction and entered into contract. He was authorized with the company who are designated by this legislation, sanction legislation. American company, which of course it is daughter company registered in Russia, they fired this person, and this person claimed to the court and was reinstated at the job with compensation. And the reason of the court was it's some kind of American sanctions. This employee followed Russian law.
I bring Mr. Friedman in here, particularly because also as kind of like a foil to our British, almost anti-American motion. As a representative of a transnational American company, in the first instance, do you agree with what Mr. Swainson said about the unsubstantiability of certain sanctions? And in the second instance, if you'd like to comment on what Elena just said.
Thank you. I guess I come to this question from a rather unique perspective, and that is Philip Morris is a U.S. company, a U.S. listed company that really has no operations in the U.S. So we face these dilemmas every day in our business because we only operate overseas. That's point number one. Point number two, I agree with Mr. Swainston that in fact the American authorities don't give concrete guidance. They give you sort of, if you will, a prosecutorial intention, but you never really know the precise outlines of the laws, whether they be sanctions, whether they be corruption, anti-corruption laws, and that makes it very difficult for companies to make decisions because the potential consequences, particularly if you are a U.S. corporation, can be dramatic. So that tends to lead companies to be very, very conservative in their interpretations, in a way that I think lead to the frustrations that have been highlighted here by Elena and also by Michael. Our approach, obviously, is to try and find a way that we can reconcile these tensions, and I wish I was in a position of a European company to sort of choose my poison, so to speak, but my poison is American, and that's what it will always be. So that leads us to try to fashion ways to continue our business. We've been here in Russia since the 80s, frankly. We've been through many ups and downs in the relationships between our two countries, yet we continue to find a way to do business here. From time to time, yes, we have to pull back in certain areas because of the legal regime that we operate under.
Mark, and what about you personally? Subject to what laws do you feel yourself operating in Russia and having different passport problems?
Sure. Our Russian business obviously operates in accordance with Russian law. I am an American citizen, so that question comes up from time to time. For instance, am I permitted to give advice to our Russian organization with respect to what I believe the appropriate contours of sanctions law is in American sanctions law, or does that somehow subject me personally to potential liability under those laws? So they're difficult questions. Much of the analysis, I must say, is done locally because our local organization does not necessarily have U.S. persons, and we do try and take steps to avoid that U.S. persons necessarily are involved in decision-making, for instance, with respect to sanctions laws. But as a lawyer, I think I've gotten comfortable that I can give advice on that topic, and hopefully the U.S. government won't come after me.
What is also interesting, as you told, that avoid American citizens in the making of some deals or approvals. In reality, international companies now is worse than some public authorities have to clarify which citizenship the employees have, and it could be their very private and personal information. Do you know that many people could have a second citizenship, American citizenship? And there are now a lot of discussions about Russian law, about disclosure of the second citizenship, this is human rights and so on, but international companies, thanks or due to sanctions, should do it.
And I think you're exactly right. And at the end of the day, I think it's virtually impossible for a transnational company to try and fashion some internal role definition for people based on different nationalities. Unfortunately for us, at least, as an American company, that can drive us to a relatively conservative position. And I was interested also to hear about these potential litigation approaches. I think those sound promising, but at least for many international companies, probably extraordinarily high risk as well. And the question they will ask probably, and management will ask, is very practically, is that a risk I want to run? Or can I suffer in my business for at least some period of time until the political situation clarifies?
А вот я хотел господина Меконина пригласить.
I would like to invite Mr. Mekonin. He would like to give his feedback, I think, to this evaluation, because as to what Mr. Swenson said about the legal perspectives and prospects about the legal procedure at the level of the European EU, Rosneft has been litigating EU versus those sanctions based on this, Mr. Swenson's attitude. You, as the representative of most important Russian law firm, what are the prospects of such a court litigation for banks, and what would be the repercussions for those banks on the basis of predominant position? To your way of thinking, are there those prospects? Maybe the BA is in the litigation already. As to the circumstances of the case, I cannot judge as the attorney, because I haven't seen it, but a right to trial, a right to claim, this company has it. It's actionable. And within the EU, maybe, and we saw the proposals to contest sanctions, mindful of WTO legal frameworks, and it was well substantiated. If we are to judge on the merits whether sanctions are substantial or not substantial, grounded or not, it's more like soft law, but not hard law. It's not just political, and we don't know whether it will be just revoked overnight. But that's a good way to raise those issues, to discuss them, and maybe to come to terms at the end of the day. Thank you.
I suppose if I can turn to Mr. Nudling from the German perspective, in your experience, do you see, I suppose in the financial area, do you see any particular solutions as referred to by Mr. Swinston in his introduction of such a nature? Do you see that your clients, particularly with regards to the financial actions and the limitations on their financial interaction, could take a course in that direction?
So thank you for having me. The approach is very interesting, Michael drew, because you have to get your hands around these things. And actually, I am advising Russian companies who want to invest in Germany and to buy some bad debt from German banks. And I'm in talk with the German banks right now, and they are rather reluctant to deal with Russian companies right now, due to the political situation, of course, but mainly because of the KYC approach of the European Commission, Know Your Customer. So that's anti-money laundering legislation, and because they are afraid that there will be some legislation from the US imposed with extraterritorial reach that could affect any company being forced to disclose business relationships with Russian peers. Like, I would like to illustrate that this with the FATCA legislation, which is the Foreign Account Tax Compliance Act, which came into force in 2010, which affects banks, of course, because banks are quite important for any economic system, so therefore it's highly regulated. And the government, the US government, generated 7 billion of fines from 50,000 individuals, so it was quite successful from one point of view. But on the other hand, the US government tried to address Swiss banks, US offshore money at Swiss banks, undeclared money, and they did so by imposing, they threatened the Swiss banks not to pay dividends in the US to the Swiss banks. Therefore, the Swiss banks were forced to disclose their customer base, US customer base. And but actually that's not as successful as people think, because for 3 reasons. First off, the US authorities don't use the data they have from the data leaks. There are all the data leaks from different banks, especially from UBS. There were some prominent cases. And the US did not use these names they got from the data leaks. Second issue is they failed to get the biggest fish, which is in particular Raoul Weil is his name. He's the global head of private banking, UBS. And he walked away. They sent him to trial and he walked away because there were some flaws in that trial. So, and the third thing is the US government has a tendency to let the big banks go because they're afraid of what happened if they were approaching the big banks because of their importance. So UBS ended up in agreeing to $780 million in fines, whereas the US customers, 19,000 US customers, are supposed to hold $20 billion in Swiss accounts. So if only 50% of this 20 billion were undeclared money, UBS ended up in paying 8% of this money as fine, which is rather reasonable. And the same thing happened to Credit Suisse, who paid $2.6 billion, and they said it's not really material for us. So, and Credit Suisse has 22,000 customers, US customers, and they disclosed 238 customers to the US authorities. So maybe there's a gap between the appreciation of the US government and the reality there. And actually the government tends to address only sure shots. So like they try to sentence a 70-year-old lady to 6 years imprisonment because of 600,000 undeclared taxes, while they let off the big players. So why is that? One major reason is that the Swiss banks in particular do some lobby work in Washington, are quite successful, and some big players in the US Swiss banking area are well connected to the US government. Actually, one of the executives of UBS is a dear friend of Obama, so maybe there's a reason why these things are not addressed as they could. So what might happen now is there are some experiences, there were some mistakes in Switzerland, so the US government might reach out to other tax havens like BVA or other countries and also address the issue I just mentioned, that they will force other companies, not only banks, to disclose their Russian or any business contacts they have.
course, on the topic of Switzerland, to address the elephant in the room, there's another obviously very important action taking place as we speak in Zurich with regards to football and the United States. Of course, we'll be all watching that as it happens. I think one of the issues that comes out of this is the punishment fitting the crime. On the one hand, within sanctions, the punishment doesn't seem to fit the crime, and yet on the other hand, with elementary tax things, the punishment is definitely far greater than the insignificant crime. But I think this is an issue for another discussion. We've had a round on sanctions. I wanted to move slightly further because we're getting closer to corporate law. I wanted to move into the next area that we definitely wanted to discuss about was mergers and acquisitions, and particularly because we have so many corporations present. I wanted to ask Oksana for a quick, again, overview on the M&A and the application of issues within this area of extraterritorial effects of national law.
Thank you. So we touched so many different topics on the extraterritorial effect of legal norms, and I'm afraid that almost all of them do affect M&A activity. Russian M&A activity or M&A deals with Russian origin or Russian participation are complex in themselves. They are very often governed by non-Russian laws. There is an overarching agreement which is governed by English laws, for example. There are often different jurisdictions involved because many companies who are parties to an M&A transaction do have holding structures in many different jurisdictions, like a BVI, less so Cyprus in last time, but Luxembourg is getting popular. Also, once you get the transfer of shares in one of these offshore jurisdictions, you have to run to a Russian notary and make sure that your shares are transferred under Russian law as well. So it's difficult to manage a deal. And now we have new topics like sanctions, like FCPA, like what Yelena said, also anti-monopoly requirements. And I wanted to see how it affects different stages of the transaction. Structuring the deal, are we getting more into the Russian reality, trying to structure the transactions between Russian entities only, without any offshore element? Does the new law on undesired organizations, which will take effect next week, does this affect M&A activity in any way? Because the undesired organizations, which could make difficulties to Russian security or Russian public order, are actually not allowed to transact with Russian companies. What happens at the stage of due diligence? What happens at the stage of transactional documents? Do we have new conditions precedent? Do we have new representation and warranties resulting from this extraterritorial effects? And what happens at post-completion stages? For example, what we are seeing as advisors very often, that the deal is good, there are no sanctioned persons involved, but there are very reputable parties involved. And they are concerned once, for example, the asset is being sold. What happens to this asset afterwards? Maybe it is just bought for someone who is sanctioned, so there must be certain post-completion obligations on the buyer, for example, not to sell on this asset to a sanctioned person. So there is additional complexity to what I said is already complex in Russia. And it would be great if Mark could comment from his personal experience, how do these laws affect an M&A deal?
Yeah, listen, again, I can't help but look at this through a U.S. lens because I am a U.S. corporation, but all of the things that you've identified have to be dealt with one after another in any transaction. And I should mention that these issues come up not only in straight-up acquisitions, which I'll speak about mostly, but they arise if you make an equity, take a significant equity stake in another company, whether a Russian party taking a stake in a non-Russian company or vice versa, or commonly in joint ventures, particularly in places like Asia or the Middle East. So from my experience, you really have to do four things in any of these transactions, and you've mentioned them all. First, obviously, is pre-acquisition due diligence. and thinking about the extraterritorial effect of the laws, both the UK Bribery Act and certainly the Department of Justice in the United States have made pretty clear what they expect, at least from American companies, with respect to pre-acquisition due diligence. So that obviously requires you to have the right people on the ground, for those people to have the right instructions as to what they should look for in the context of their due diligence. And critically, I think, it's important at the end of the day to talk to the target company and its management. Particularly in jurisdictions like the Middle East or in Asia, this has to be done in a culturally sensitive manner. We are not making moral judgments about the way business is conducted in any of these jurisdictions. We're about trying to figure out a way that we can conclude a business deal that is favorable to all parties and make it a success. So it's important to raise the question, is there something about the operation of the target company that we absolutely have to know about because we can't operate without it, and to get as much comfort as you can. You mentioned representations and warranties and structuring of transactions. Certainly you can address some of these risks in the transactional documents, and some of them through the way that you structure the agreement. But unfortunately, or fortunately, for us as an American company, usually you can't cover everything in the transactional documents. So the third step really is a post-acquisition review of the business that you've just acquired. That's something that you have to do immediately from our perspective, and if I focus on anti-corruption risk, this is really a question of triage, putting the right people in there at the right time, particularly in the legal and the financial functions, to understand where money flows within the organization, touch points with government officials and so forth, so that you can take immediate steps to address those potentially problematic areas the minute you own the company, because at least for us at that point we are directly subject to U.S. law with respect to its operation. And after that, of course, it's important to what I would call socialize the issue. And again, I come back to this notion of not making moral judgments. It's very important to operate effectively in a transnational context to understand the local people. None of our cultures are the same. None of our governmental systems are the same, yet we all are interested in making good business together. So you have to really find ways to introduce the controls that are required from the point of view of your local law, but to do it in a way where employees in particular understand and ultimately buy in. If you come in like a preacher or a priest on a pulpit, I think that is an approach that is bound to fail.
Thank you, Mark. That's very helpful. Michael, you're probably seeing all these joint ventures and M&A activities when it's already getting very problematic and when it comes to disputes. Do you have any input, any views on, some changes in what is disputed on M&A activity now with the impact of these extraterritorial laws? Are you seeing anything like that?
Just before I deal with that, can I return to sanctions just for a short point? My position was summarized as anti-American.
We can sanction you on that, can we, Mike?
I just want to make clear that I was once admitted in California. I have many American friends. My position is not anti-American on sanctions, but it is pro-rule of law. Most of the Americans that I know would subscribe to that. Dealing with M&A, I don't do deals. I occasionally try to break them up, or I deal with matters when things have gone wrong. We haven't had a lot of M&A litigation in London related to extraterritorial effect of law from other states. But it is perceived as a field of potential business for lawyers and therefore activity, especially because of the Bribery Act. And in particular, because of transactions, resource transactions that are happening in resource-rich parts of the world, where very often the rule of law is poor. And what has been noticed in a number of cases is that many countries in the world have a very good letter of law, which is fulsome in its condemnation of corruption. However, that law is not applied in the most obvious jurisdiction. Under the Bribery Act, it is applied in London if any aspect of the transaction went through London. And because of London's banking connections, it's very often possible to find an anchor defendant in London through whom you can bring in other parties. And that is perceived and is becoming a substantial area of litigation.
On that point, I just have two questions, if I can. I think particularly interesting, partly because when the Serious Fraud Office was created, obviously the Bribery Act was a mandate to operate abroad for the Serious Fraud Office. I think one of the I suppose, the specification that I, as a British national, obviously living in Russia, would like to ask you, I heard the perception that the Serious Fraud Office would not use that mandate unless the deal was over a certain threshold. In this instance, I believe I heard it was around £1 million. I'm just interested to know the pragmatics, that actually if there have been any investigations into deals where, if there is a financial threshold for the Serious Fraud Office to get involved.
Well, again, I deal with civil litigation and therefore not so much with criminal matters and the Serious Fraud Office. But it is the case that the Serious Fraud Office is not apparently very active in these areas. A particular point to note is that since anti-money laundering was introduced, and there was a focus on criminal property in London, including mansions in Belgravia bought with ill-gotten gains, total seizures over, I think, the last 5 years have amounted to about £1 million. And that barely buys you a wardrobe in Belgravia. So the Serious Fraud Office sounds good and sounds effective, but doesn't discourage money coming to London from whatever source, and the same applies to deals. What I meant was that if you've got illegality by the standards prescribed under the Bribery Act, and if you can bring some aspect of the transaction within English jurisdiction and identify an anchor defendant, then you can effectively unravel deals. If you come second in bidding for some corporate target because the winner won by a bribe, the winner can be sued for damages for your loss, potentially also restitution of the profits that they've made. And actually, it's quite good because you can wait for the limitation period to let them try the business and build some profit before you take it away from them. So there are things to be done, and it is perceived as a growth area.
Very practical advice for us, I think. So, thank you. Alan, do you have the second question or no? Okay, it's gone. Okay, thank you. Daniel, what about you? Do you encounter extraterritorial norms on M&A deals? Obviously, you deal with very many countries and have very international business. So, if you could comment on your vision
actually,
and views.
I think legal fees and due diligence fees rose in the last couple of years tremendously. It's quite if you have a mediocre deal for one digit in a million numbers, you end up with paying $1 million just for due diligence. So that's kind of tough for that kind of deal. And there's also another component. It's not only the extraterritorial laws and the national laws you have to take into account. It's also some sort of soft law, and especially enforced by the stock exchange. If you're listed at a stock exchange, the stock exchange will require you to fulfill certain corporate governance things and so on. So there's a third component, a third enforcer, beside having the administrative enforcement. So, and you have to take this into account as well when you structure a deal.
Thank you. And Yelena, no additional comments?
No additional comments here.
Okay, thank you very much. And I think that we can link the M&A activity to the Asian topic here and see whether Andrei has any insights on that.
Евразийский таможенный союз. Мне кажется, это очень действительно тема на...
I think the Eurasian Customs Union is quite a topical theme here because it's gaining momentum, so it repeats certain norms and echoes norms that are applied within the European Union. Here we confront a question: how you plan just your legal presence, what kind of legislation is pending to be approved, and likewise in the European Union, do you think of some counterpart measures or some forum shopping within the Eurasian Customs Union? So maybe some transnational companies are more prone to some certain specific jurisdiction. So can you probably give us some positive perspective of this? So the positive perspective is that the new agreement that entered into force on the 1st of January 2015, it encapsulated not only the customs union, but also the other elements of public regulating, technical regulation in the form of technical norms, anti-dumping regulation, and even partly a financial regulation. And the part which is to be discussed within the extraterritoriality is antitrust and competition law. So for my American colleagues will correct me if I'm wrong, so for over 100 years in the United States, for antitrust law of the United States, they have been very successfully exporting and transplanting their law to Europe and other jurisdictions. And over 50 years, during the 50 years, so it was a singular practice which evolves to become a massive one because the Commission for Europe issued certain regulation because these have to be have extraterritorial force, and the Eurasian Economic Union and this entity can be very helpful to the companies that have an interest on the Russian market and just want to place their subsidiary or just have some Russian managed entity because they can use the advantages that have been evolving in the European Union and the United States and benefit from it. For example, US gave us the aftermath effect doctrine in the antitrust, when you can involve foreign organizations, involve them in the investigation for the American customers and markets. And from the European Union, we could have taken on board the doctrine of the economic subject when extraterritorial effect of the antitrust competition will cover some other organizations dealing with the European companies. So this new entity is fully equipped with the wide-ranging instrument for carrying out antitrust investigations involving more than one state territory in our customs union. However, the text of the convention as of today only provides the possibility of discussing the adoption of the doctrine modeled on the European economic subject doctrine and viewing the just holdings that are based on the Eurasian territory. So unfortunately, we cannot hope hope very much to be successfully using the aftermath doctrine. There were some amendments made into this vein. However, the monitoring showed that only one case reached the highest supreme stages, and was only one checkup document. So extraterritorial measures are not very effectively used so far in the Russian Federation. However, there are ministerial plans for that, for antitrust bodies that want to extend and expand this practice. So summing up, we can say that if we were to balance the sanctions against this, the sanctions which can be judged as to the dominating position of the antitrust law, so that we could do some forum shopping, so the Eurasian Customs Union can offer you new opportunities, the ones which have the judicial remedy back up, because the new court has all the legacy of the previous entity, so it provides for the protection of the interests and engage in disputes with foreign organizations, especially in terms of the decisions of the Antitrust Commission. So in terms of the forum shopping and defending one's interests, one can just basically move your offices and just your targets into the Eurasian Customs Union will be much easier to work. I think this is a very interesting and promising topic, and we can say that the existing sanctions, which we discussed so much in depth at the beginning of our roundtable, provide some incentive for just developing of the Eurasian Customs Union in terms of the legal perspective. So we see from the economic perspective, some bypasses for the products that somehow reached Russia against all the sanctions with a different label through such friendly states as Kazakhstan and many other channels of that kind. However, other things being equal, if we did not have any sanctions, would we also see quite a prompt solution of these issues through the Eurasian Economic Union creation, or what? Well, so we started developing this entity before the sanctions hit our country. So yesterday, Mr. Konovalov was attending one of very interesting sections where some ministers and the chairman of the union were very optimistic about the further development of this new entity. So this was quite very good at advertising for the Eurasian Union. It is not yet enforced, but it will be, and so the sanctions will really push this process and accelerate it. There are no other choice. Andrew, when CIS was established, there were some jokes that there is EU and the CIS, so CIS will become as powerful that it will embrace the EU to become one single global organization, so we'll win. As to the Eurasian Union, so what are the perspectives there? Is this organization meant to embrace many members like Italy and Austria? What is the response from these countries? Will they also join it? It is not necessary to join it, so politics remains politics. Historical background is still there. However, Eurasian Economic Association was then set up with, but Eurasian Economic union is a different thing, because it is entitled with the power of entering into different agreements. This Eurozac only entered into technical, very short-term agreements. So our entity is fully entitled to affect the member countries and also contracting parties through the agreements, including the customs and antitrust and technical laws and norms. So we have quite a different legal instrument, and just the major principles are clearly spelled out, and just you can enter into an agreement with us without being our member, because the competition law of the US and the EU contain just a mutual agreement for competition law application, not between the United States and EU, but the EU itself, that also can conduct negotiations basing on the US legal norms and procedures and others. So, and vice versa, you can do it basing on the Eurasian economic union. It was not only a code of all CIS concluded agreements, but this is a newly born entity that can step outside.
Thank you very much, Andrei. We've had a very balanced discussion, starting from the negative, talking about the current and looking forward to the future, the optimism. I think we haven't had a balanced discussion in terms of language, I'm afraid to say. But before we go into talking about our conclusions and what happens next, as we promised, we wanted to get some input from our audience here. And I wanted to give the opportunity to people in the room to ask questions of our specialists here, some issues that may have arisen during our discussion. I think, as Oksana said, we've covered a large number of the topics that are obviously present in the three areas that we decided to indicate. And as I said, I just wanted to give the opportunity to the floor to take part in this discussion, to give their question to our specialists. Do we have any questions, ladies and gentlemen? Yes, please.
Good morning. I have a question to Mr. Swainston. By the way, I'm a forensic partner of PwC, so I'm dealing quite frequently, like yourself, Michael, with the cases when M&A transactions came to a failure, and when there is a strong disagreement between the buyer and the seller. From your practical experience, what are the major reasons of the disputes which followed the agreement, the happy agreement between the buyer and the seller? And what are the reasons of them being so unhappy after a while with each other? And how that can be prevented going forward?
If I knew the answer to world peace, I would be in a different job, I'm afraid. Most often, it's breach of warranty for the run-of-the-mill case. From this region, one sees a lot of falling out over corporate governance, which is usually reflected in a shareholders' agreement in relation to a holding company with companies or assets in Russia. And it's a feature of contracts that people write them when they're optimistic, and sometimes optimism prevails over precision, and sometimes that's deliberate, but you get differences of opinion on how businesses should go forward, and at that point there is minute attention to who's got control, who's entitled to appoint the general director for this period, what matters have got to go to sanction of the shareholders as a whole. And that really is the kind of dispute that we see, especially in London, very often under LCIA jurisdiction. So those two things, breach of warranty and people falling out. I think that it's always valuable to have a prenuptial agreement, if you like, as corporate partners, and to think of the worst. And people very often don't do that. On the other hand, I'm also conscious that, in my experience, with the exception of Daniel, I'm sure, lawyers don't make good businessmen because they're too focused and refined on points of detail that might be completely irrelevant in the running of a successful business. So it's always a question of balance. But you should at least do two things. You should think about governing law, and you should choose a governing law that is balanced between buyer and seller. And I would suggest that's one reason that English law is so popular. Secondly, you should choose a jurisdiction where the law will be applied in an even-handed way. And then at least you've got some insurance and protection down the line. Although it's fair to say that at the outset of a contract, both parties are very confident that they want a tribunal that will apply the law and reach a decision on its true merits. Only one of them thinks that afterwards.
Do we have any further questions, ladies and gentlemen? Any other brave people to talk on the topic of sanctions? I'm sure there are, it's just no one's brave enough to stick their hand up. No? Going once? Yes, please, thank you.
Good afternoon. Can I ask my question? I'm from Gazprom Neft. We faced a situation when one company, a legal firm in one of the Central European jurisdictions in the European territory, rejected joint work on the assignment. They basically introduced their own sanctions. So we were very upset about it. We continue working, and we are now viewing our risks about continuing to work in this same jurisdiction, because an intermediary bank or consultant may tomorrow say, well, I watched TV and there were horrible sanctions. No, I cannot continue dealing with you, goodbye. So what do? Do we probably stop working with some specific dangerous jurisdiction?
Finding that balance, whether it goes all the way down to the personal level with friendly relationships with people that you've been interacting, and whether you allow the sanctions to interfere in those friendly relationships. Oksana, do you have any comment on that?
Thank you, Alan. Да, на самом деле эта тема очень актуальна.
This is a very topical and burning issue indeed. I'm in legal profession, and I'm the advisor who constantly thinks whether these sanctions are to be applied to me or not. And many foreign legal firms formally do not fall under the sanctions because their business is so structured, still use their best practice effort. These are not internal sanctions, but this is an example of best practice when you comply with the sanctions regime, because informally there are head offices in some other countries who adopted the sanctions. What can cooperation do to protect itself from it, and whether can you find protection at all? When you are searching for advisors and counselors, we are asked about the confirmation and there's a list of situations where we can potentially reject our services. For example, if we speak about the issue of new stock during the transaction period, can it affect the possibility for the consultant to continue working, because the issue of new shares already falls under the sanctions regime. In this case, we as consultants basically have to put you in contact with somebody who can take it over from us, and you can ask your counter agent for this backup plan for some additional jurisdiction for the issue of your share. It might be Hong Kong or Singapore, or the company which which is located somewhere where the sanctions do not apply, that can take over from us in this transaction. However, beyond the sanctions, there are situations that force us to reject continuing support of the client, and on the one hand we fall under the effect of the solicitor's rules, where in some cases we cannot reject continuing our services and representing our client. In some other cases we have to reject it because we fall under the sanctions, and we take a decision of how we can deal better with such a situation. However, there is no universal remedy I could share, so in the rejection of continuing to provide services according to the agreement due to the sanctions might not be qualified as a force majeure situation by the Russian court, or vice versa, can be qualified as a force majeure. It's difficult to analyze how the situation will unfold, so you have to be very selective when choosing your consultants.
Liability for US nationals being in the room with a sanctioned individual. I'm just interested on the practical application of that and being able to prove it. Has there anyone been taken to court for that personal liability yet?
I'm not sure I know the precise answer to your question. Certainly not in the Russian case. I haven't seen anything. I was very interested in this comment over here from our member of our audience, because in our industry we often face very similar situations where we're engaged in what we think of as a standard business transaction, maybe with people who we supply products to or sell our products, and they find themselves reading in the newspaper about a draconian law, and because they've read it in the newspaper or find it a potential risk to their business, they would rather cut off our commercial relations. And I don't know that I have very much to add to what Oksana said, other than to say sometimes this is a situation where the lawyer can play a very positive role by going and maybe talking lawyer to lawyer with your business colleague and trying to explain your perspective on the scope of the law, and hopefully that can help you continue with the business relationship.
Sorry.
If I may add something to this, we are in the construction business, so this is a business where people used to work with cartels and pricing agreements for hundreds of years, and we are now getting used not to for some years. And well, actually, as you might know, there are leniency programs for those people who go to the authorities and tell them about any cartel agreements. And this is exactly the problem addressed, that our competitors with whom we have to work go to the authorities or just intentionally meet with you just in order to use the leniency card, you know. And but you still have to work with these people because it's a confined market, and you know you can draw lines at the borders of the production site. So it's a tough topic to deal with.
So to give us a quick round of a preliminary conclusion to our discussion today, if you'll allow me, what I'm hearing here is that the human factor, or what you perhaps could call the application of national laws, seems to be more relevant or closer to the dynamic of continuing business over perhaps the extraterritorial applicability of national laws from other countries. And I'm interested to know where again each of our panelists sees the dynamic winning out, whether the national laws or a return perhaps in the United Kingdom to national law is more of a strong statement, or whether you see the possible application of further measures that have extraterritorial application. And I'd like to ask Yelena to start us off with the conclusions, if that's possible.
To be very short, I would say that that extraterritorial applications of the law, for me, it's like following Marx's idea, supervision on basis, and this construction cannot live without some kind of new regulation. I think the public law, such public law, not like international public law, like or how to say ordinary term of this word, like collision of different antitrust law, sanctions and so on. It needs their own regulation, like international private law. Not always it is ideally you can understand law of which jurisdiction should be applied, but at least it's some kind of map and navigation. And this situation we discussed today, it is raw navigation of international companies and their consultants, which is not clear game of rules of the game, and it require huge internal researches, and companies spend money not for development but for some kind of finding the rules of the game, I would say.
Mr. Newling, what do you think?
Well, I think there will be some sort of cohesion, not unification. We had this at the panel yesterday. There will be no unification, but there will be cohesion towards some issues which have to be governed on an international level. But at the same time, there have to be national laws to address national issues, which are different in each country because of the political, social, economic, and whatever influences that are different in each and every country. So therefore, there will be, some supranational law governing the supranational issues, but there will always be national laws as well. And there has to be balance. What that be, I can't say.
Господин Миконин, как вы считаете, тенденции в какую сторону?
Mr. Mikonin, what do you think about the trend versus extraterritorial or national versus national laws? Which will win? I think that transparency is the key factor today, because the nature of information changes, because inside Russia we talk about the tax authorities and legalization oversight bodies. Almost all information is transparent. Neither Hong Kong or BVI or Myanmar, no sense to hide like we did before, because extraterritoriality will be huge. Just it is important to choose the right and good domicile for doing business and tax regulations, and transparency, it's important.
At yesterday's plenary session, there was a focus more on harmonization than convergence of rules across nations, and I think that's actually correct. I don't think there will be a, if you will, public law solution to this problem. I think those of us who advise transnational companies will forever be struggling with this issue of compliance with national law as well as transnational standards or the laws of our own jurisdictions. I agree 100% with Michael's comment earlier that the key for international business is the rule of law, and not only the rule of law, but the effective judicial relief that you can get in any particular jurisdiction. We will always find ourselves balancing between national law and international law, or the laws of our jurisdiction. But the key point is, if we're doing what we think is right, we need to be able to defend ourselves, and that requires an effective judicial at the end of the day.
Thank you very much. And finally, Mr. Swainston, on the balancing act.
Well, some of the comments just made ranged from extraterritorial application of law to supranational law. In terms of supranational law, coming from the UK, we've got an interesting prospect of a referendum before 2017 on whether we pull out of the European Union. Who knows how that will go? I expect that we will stay in, but I think it's important to notice the reasons that that is happening. And I would suggest that to some extent it's because the EU delivers too much law and interferes in too many aspects of life. Now, we've talked about sanctions, which are destructive in international relations. We should recognize that a great deal of international law and conventions is very, very useful, especially, for example, anti-money laundering and bribery, which are fundamental aspects of legislation for the developing world. All of that is good, but I would suggest that states should stop interfering where they don't need to. Good fences make good neighbors, and we can cooperate on the things that everybody finds important.
I think that's a very strong statement. Oksana, would you agree?
I would agree to that. Ну и вот мои заключительные комментарии.
So my concluding remarks is that we, I think, had a very fruitful and interesting discussion, and we ended up having offering a lot of practical advice as to what we can change or take on board in business. These discussions will continue further. Thank you, Ellen, for your wonderful moderation, and thank you all for coming to be with us and supporting us. Hoglevel will have one more panel from 5 to 6 p.m. about the joint ventures and cross-border partnerships. So those who wish and have time, please come to hear what we have to say. And also we have to remember that Forum is not only a business program, we have also a wide-ranging cultural program, and just legal drink is one of the elements of it, where you can have very good dress. Hoglevel also is part of it. Commerçant, together with us in a Sardina bar, welcoming you. Please come to see us tonight if you have time and wish. Thank you for participation. Ну, конечно, на такой конкурентной, высококонкурентной ноте прекрасно закончить это заседание. Благодарю вас, Оксана, как модератора, и всех присутствующих.